Hi, my name is Robert Chelle with Chelle Law, and my law firm assists physicians with employment contract issues. Today I'm going to talk about why without cause termination is so important in a physician contract. So, what is without cause termination? Essentially, it allows either party to terminate the agreement at any time for any reason with a certain amount of notice to the other party. Now, the reason why this is so important is if a physician enters a job, everyone expects a job to be great, right? You don't take a job expecting you to want to leave immediately. But things change, or it certainly can be different once you start. And so let's say a physician takes a job and after a few months, it's absolutely clear it's either not a good cultural fit, maybe they're on some kind of productivity compensation and the volume isn't there. Maybe they just don't like working with the management or the other physicians. Whatever the reason, they've decided, I do not want to stay here. And so without cause termination will allow that physician to give notice, work out a period of time, and then move on. So the average length, or at least the standard length for most without cause termination notice periods, is somewhere between 60 to 90 days. Anything higher than 90 days causes a couple of problems. So anytime somebody gives notice, the dynamics will change between the physician and either the other physicians or the organization itself. You're no longer in the long-term plans. And so sometimes there can be bad blood as well. And so a shorter period of time to have to work out whatever it is advantageous. It's just better. If you had 180-day notice, you're there for 6 months dealing with potential kind of an awkward environment. Another thing to consider is the longer the lead time, the harder it is to find a new job. If you're coming out of training, everyone comes out at the same time. So all the employers understand this, and there's kind of a rhythm to when they offer jobs and start onboarding and all that type of thing. If you're out, you've been out for a while, and then you decide to switch, it can be at any time, but most people don't post for jobs 6 months in advance. They will say, we have a need now. So if you have a 6-month notice requirement for your job, you may lose out on job opportunities because they need someone much faster than 6 months. And so they're going to find somebody and kind of leave you in the dust, so to speak. So 2 main reasons: don't put yourself in a toxic environment for a long period of time. And then 2, helping yourself to, shorten it down so that you can find a new job more easily. So in the contract, it's going to state, how much notice you have to give. And let's just say it's 60 days in this example. It will also state it has to be in writing. So you need to find in the contract, it'll be under the termination section. And it's going to state, it will say like without cause termination or for no good reason or something like that. And then it'll just state either party can terminate the agreement with a certain amount of notice to the other, as I said before, in 60 days. There's another section in your contract that's called either notice or notices. And it's going to state exactly how you can provide notice to the employer. So it'll state either it needs to be certified mail and delivery. Most contracts don't have email. Certainly there's no verbal acknowledgement, no fax. So if you were to tell your boss, hey, I'm leaving in 90 days, but not give them some kind of written letter that states you're leaving, they could potentially force you to work for another 60 days until you actually give them effective notice. So those 2 sections, look into the without cause termination section to see how long or how much notice you have to give, and then look in the notices section and make certain that you're able to provide effective notice. I've had a couple times where physicians have called me after the fact and said, I emailed my boss, it was 60 days notice. They waited 45 days and then came back at me and told me I didn't provide them effective notice. and now they're saying I have to give it another 60 days. Well, obviously it's pretty vindictive on the part of the employer. They were mad, and they did that on purpose just to kind of screw with the physician. But if you don't give effective notice, it doesn't count. So make certain you're following both of those things, giving the proper notice and then following the notices section. Now, what happens if you decide to leave a job and don't give the proper amount of notice? Well, many contracts will have penalties associated with that. So, for instance, like a common way of doing it would be to penalize the physician, whatever their kind of average daily rate is, for every day that they didn't give enough notice. So if it was 60 days and they only gave 30 days, then they'd owe 30 days of their average pay to the employer, which can be a significant amount of money, obviously. So you want to make certain that you're giving as much notice as is required in that without cause section. Therefore, you can't be penalized. I guess theoretically they could come after you for recruitment costs, locums to cover your shifts, or if you're an outpatient or something like that. It'd be pretty rare for them to do that, but you are opening yourself up to some kind of liability if you fail to give them the specified amount of notice in your contract. Hopefully that was helpful. If you have any questions about your employment contract, you can always call my law firm at the phone number listed below in the description, or you can reach us through our website, chellelaw.com. And I appreciate you watching the video. Thanks.